So thank you everyone for taking the time today to join us. My name is Aisha Wu. I'm the Communications Officer for the Alberta Land Institute, and this is the third webinar in our lunchtime webinar series. The Institute aims to connect research and policy for better land management on Alberta's changing landscape. And the goal of these webinars is to encourage knowledge sharing and discussion about a variety of land use topics relevant to Alberta and beyond. When speaking about land use, it's important to acknowledge that the University of Alberta is located on Treaty 6 territory and respects the histories, languages, and cultures of First Nations, Métis, Inuit, and all First Peoples of Canada, whose presence continues to enrich our vibrant community. I'm going to pass it off today to today's moderator, Dave Poulton. Dave is the Senior Advisor at the Alberta Land Institute. He is a researcher and consultant focusing on conservation policy and is currently a PhD candidate at the School of the Environment at the University of Queensland in Brisbane, Australia, with his research focusing on federal Canadian perceptions of mitigation options in project development. So, with that said, you can go ahead and take over, Dave.
Thanks very much, Aisha. Today's topic is property rights in Alberta, which is always a popular topic and important one for a broad range of land use issues. Back in 2013, Eran Kaplinsky and David Percy published a guide to property rights in Alberta with funding from the Alberta Land Institute. It was one of our first public projects. The guide has been referred to across the provincial government and in many public processes and continues to be one of our most referenced sources. In the 12 years since the guide was published, there had been an evolution of property rights in Alberta. So Eran and David have agreed to join us today as guest speakers to talk about property rights and go over some of the changes that we've seen. Let me first give you a little bit about our speakers. Eran Kaplinsky is our former colleague as research and former research director at the Alberta Land Institute. He teaches in the areas of property law and planning law at the University of Alberta. He holds a Bachelor of Laws from Tel Aviv University, Master of Laws from the University of Toronto, and a Doctor of Juridical Science from the University of Toronto. Professor Kaplinsky is also a research affiliate of the City Region Studies Center. His teaching and research interests include land use planning and regulation, law and economics, municipal law, and property law. Professor David Percy, QC, I guess KC now, was interim dean of the Faculty of Law at the University of Alberta between 2019 to 2020, and dean of law from 2002 to 2009. His teaching and research institutes are in energy law, water law, and contracts. He is co-editor of Contracts, Cases, and Commentary, now in its 9th edition and used in law schools across Canada. He wrote the framework of water rights legislation in Alberta, as well as books on wetlands and groundwater. Presentations today will be followed by a Q&A. You can post your questions in the chat throughout the presentation, or wait till later and use the hands up option and we can recognize you. Please make sure your questions are brief and to the point so that we can get as much discussion in as possible. And with that introduction, I will hand it off to Eran Kaplinsky. Eran?
Thanks, Aisha and Dave, and thanks, ALI, for hosting us again. Property rights never cease to be a topic that captures the imagination and the public debate. And it occurred to Professor Percy and myself that it's time to bring the guide up to speed, talk about some of the changes that occurred in Alberta in just over a decade since the publication of the guide. Our presentation today is going to consist of two parts. I will provide a brief and very general overview of the subject of property rights from a legal perspective. And then my colleague David Percy is going to talk about the impact of property rights on some recent developments in the area of energy development. So let me get started and situate the topic. When we're talking about property rights, we're talking in this context about the ability of a landowner to resist state action, which would typically be a taking of property or the regulation or restrictions on the use of property. There are, of course, other aspects to property rights, including the relationship between neighbors, but that's not really our topic today. Property rights serve a number of important functions and values. Obviously, they promote and they stand for the kind of values that we hold dear in a free and democratic society, including the dignity and the autonomy and the privacy of the individual. Property rights also decentralize political power. They ensure the rule of law and keep the power of the government and of the state in check. Property rights encourage stewardship and investment in land in the sense that who would do any of those things if they knew that their property could be taken from them at any moment. And finally, property rights perform an economic function, especially the right to compensation, which ensures that the government has to confront not just the public cost-benefit analysis, but also to include any private harms resulting to the individual, those individuals whose land, whose property interests are affected. The question of the origin of property rights has been, I think, in the case law, in the commentary in the past few years. There is an obvious comparison to other jurisdictions, namely the United States, but not only the United States. Those countries who've chosen to entrench their property rights in and give them some constitutional protection. That's not the way that Canada chose to go. The right to private property is not famously a part of the Canadian Charter of Rights and Freedoms. And in this context, property rights are really shaped by centuries of the common law as well as by statutory law. The common law is, as I mentioned, quite important. Traditionally, it focused on private relationships between landowners, neighbors, other users. But from time to time, the common law stepped in to affirm the rights of the individual vis-a-vis the state where necessary. And I have here a quote from a very famous 18th century case where agents of the crown basically ransacked private property of a political dissident. And the court here stepped up, emphasized the importance of the right to property in a free and democratic society, and found for the claimant, emphasizing that any intrusion into private property has to be authorized by law. Anything other than that would amount to trespass. So let me talk about property rights in Alberta. In Canada, the taking of private property on the use and enjoyment of property are permitted in accordance with statute. And in our federal system, the power over property is almost without exception reserved to the provincial legislatures. And what this means is that the Alberta legislature can pass a variety of enactments and regulations that authorize almost any type of interference with private property, given again that private property is not constitutionally protected. And that leaves an important role for the courts, which is to interpret those statutes passed by the legislature and really to interpret the scope, the extent of the power of the state over private property. There are basically two kinds of interferences with private property. The first is expropriation and the second is regulation. So let me talk about expropriation first. And when we talk about expropriation, we are referring to the taking of title, to the taking of private land by the government for a public or for a statutory use or purpose, all of this without the owner's consent. And what makes expropriation easily recognizable is that the expropriating authority, the government, says, we are in fact taking your property. We need it, and we're taking it, and you cannot resist. There are various government agencies who are granted these kinds of statutory expropriation powers for a variety of purposes. And I have here some examples, to build hospitals, public buildings, whether it's a municipality or a government department that needs to widen a road or a highway, a utility company that requires land to construct a power line, et cetera, et cetera. And once an expropriating authority is given expropriation powers, typically they can take all of the land absolutely outright, or they can expropriate some lesser interest. They can expropriate the subsurface resources. They can expropriate a lease. And they can expropriate a right of way, essentially anything that they need. There is an act in Alberta called the Expropriation Act, and it governs every expropriation authorized by the law of Alberta. And what the Expropriation Act says is that in such cases, the affected owner will be entitled to compensation, which is intended to make the owner whole as far as possible, as far as practical. This typically includes the market value of the land that is taken by the government, as well as disturbance damages, injurious affection, several other heads of compensation, all of which are intended, again, to make the owner whole. But there's another kind of interference with private property, which is regulation. Regulation is ordinarily not regarded as a taking of property, so it is not governed by the Expropriation Act, and it does not require compensation per se, although the legislature in some cases has instructed the regulating authority to compensate the owner. This is typically not the case. So I have here an example on the slide, which is the Municipal Government Act. All of us know that our municipalities have zoning powers, the power to regulate the use and development of land, of buildings. And in Alberta, the zoning of land, basically the exercise of planning functions, does not entitle an owner to compensation except in very limited circumstances. And in fact, there is only one specific provision in the Municipal Government Act that says, in these types of regulations will entitle the affected owner to compensation, but in all other cases, the affected owner will not receive any type of compensation. There is, however, one type of regulation which is considered to be a constructive taking. This is really a concept that developed in U.S. law, where it is known as regulatory taking. And for many years, there were questions of whether there is a comparable type of interference which is compensable in Canada. We now call that a constructive taking. A constructive taking occurs where regulation, which is duly authorized by enabling legislation, when that type of regulation crosses the line. And it crosses the line in such a way as to effectively expropriate the private property of the owner by depriving the owner of the use and enjoyment of the property in some unreasonable and substantial way. And that is obviously a test that requires some interpretation by the courts. The courts have developed the tests for constructive takings in a series of cases over the years. And recently, the Supreme Court of Canada attempted to clarify this test in a decision out of Nova Scotia called the Annapolis Group decision from 2022. And according to the majority of the justices of the Supreme Court, a constructive taking occurs where two conditions are met. The first one is that the public authority has acquired some beneficial interest or an advantage in relation to the private property which is being regulated. And the second requirement is that the state action, i.e. the regulation, removes all of the reasonable private uses of the property so that the land, I would say, is essentially pressed into public service. So that kind of regulation is considered a constructive taking. Now, what happens when land is the subject of a constructive taking? Well, in that case, the affected owner will be entitled to compensation unless the enabling legislation which authorizes the constructive taking also provides that the owner will not receive compensation. Again, this is something that is permissible in Canada in the absence of constitutional protection of property. And for those of you who are interested in an example of a constructive taking, I have here on the slide an example of a recent case. Compensation was awarded in that case in May of 2024. I think that's the precise date. Finally, I should probably refer to the new Alberta Bill of Rights, which, well, we have amendments that came through just in December. And those amendments are said to better protect fundamental rights and freedoms. Now, the Alberta Bill of Rights is not a constitutional document. Technically speaking, it is an ordinary statute of the Alberta legislature, which means that it could be overruled by subsequent legislation. It doesn't have any privileged status necessarily, but it does affect, it does influence the court's interpretation of property rights. This is something that we will wait and see. We'll have to follow and see what the effect of these new amendments are. Some key provisions in the Alberta Bill of Rights are as follows. So there's a new definition of the taking of property, and it includes two things. First of all, a transfer of ownership of the property without the consent of the owner. This is already governed, of course, by the Expropriation Act. And then also an owner being deprived of all reasonable uses of that property. So we're talking here about an elaboration or possibly an expansion of the Supreme Court's case of a constructive taking. And then Section 1 has already recognized, even before the amendments, that the right to property is protected in Alberta. But there's some clarification that owners have the right not to be the subject of a taking of property except to the extent authorized by the law and where just compensation is provided. Again, this is just an ordinary law, and a subsequent law in Alberta can say, we are doing the following, and notwithstanding the Alberta Bill of Rights, we choose to move forward with or without compensation, etc. Maybe I can come back to the Alberta Bill of Rights in Q&A, but I think it's time for me to hand off the microphone to my colleague, David Percy, and he will talk about the effects of property rights in Alberta on energy development.
Well, thank you, and good afternoon, everybody. As Eran mentioned, my interest is in the interaction primarily between property rights and energy production. This means, in most cases, we ask who owns which substances beneath the surface of the ground. But as we'll see with renewable energy, of course, we are also concerned with ownership interests on the surface of the ground itself. So why is the ownership of subsurface resources so important? After all, the province of Alberta owns the mines and minerals beneath 81% of its territory. But of course, many different people own the surface rights beneath which the Alberta mines and minerals are located. And the most important principle to remember is that Alberta doesn't own everything beneath the ground. It only owns the mines and minerals beneath the ground. So anything that is not a mine or a mineral for example, topsoil, belongs to the surface owner. So the question we also have to bear in mind, of course, is that the other parts of Alberta, which are not, where mines and minerals are not owned by the province, were frequently influenced by early grants of property. So, for example, many farmers acquired their lands from the Canadian Pacific Railway Company or from other settlement railroads or for lands that were once Hudson's Bay Company lands. So there are lots of formula used at the time, but for example, if you were a farmer who obtained land from the CPR in 1902, you got everything except the CPR reserved coal. If you got the lands after 1906, you got the lands, but the CPR reserved coal and petroleum. And that left, obviously, the question, well, therefore, everything else belongs to the farmer who acquired the surface of the land, unless it's something we describe as coal or something we can describe as petroleum. So the questions that have arisen on that in recent years is where the CPR reserved the coal, who owned coal bed methane? Was it the coal owner, or was it the farmer who owned everything else except coal? So they're the sort of questions that arise when we think about ownership of subsurface resources. So I want to talk about how Alberta has dealt with this historically. And I'm just hoping to advance my slide. There we are. Alberta has a history of two techniques on how it deals with subsurface rights. What I describe as the classic approach occurred 75 years ago in the 1950s when the oil industry was just getting going in Alberta. The question arose of who does own what beneath the surface of the land, and the first controversies asked, well, if there is sand and gravel beneath the surface of the land, who owns that? Is it Alberta, which owns the mines and minerals, or the surface owner who owns the surface and some other things that anything else is not a mine or mineral? So to clarify this, the Alberta government passed legislation which says the wording is important. The owner of the surface of the land is deemed at all times to have been the owner of and entitled to the sand and gravel on the surface of that land, and all sand and gravel obtained from surface operations. In other words, if you dug down for it from surface operations, it was still your sand and gravel and did not belong to Alberta. And in very recent times, we've had more legislation like this. There was a huge controversy in Alberta in the first decade of this century as to whether or not coal bed methane was owned by the coal owner or was owned by the natural gas owner beneath the surface. So to clarify this, in December 2010, the province passed legislation which says, same style, coal bed methane is hereby declared to be and at all times to have been natural gas, which meant the coal owner had no right to coal bed methane. So that for reasons we can talk about later, it's the surface owner who owns the rights to natural gas, and this legislation says, and that person also owns coal bed methane. So that's what I would describe as the classic Alberta approach. When we look at, and I hope this has come up, under the classic approach, under this type of statute, the government has definitively stated once and for all who owns the sand and gravel, who owns the clay and marl, who owns coal bed methane, and in recent years, who owns the right to store carbon underground. All of those things have been dealt with this type of legislation, which simply suppresses any other property owner's claim to the specified resources. But not all of our legislation has taken that form. We've also had what we might describe as soft touch legislation passed in Alberta. So the most recent example of this deals with the Geothermal Resources Development Act of 2021, again passed in December 2021. Geothermal energy has significant promise in this province, and the government decided they wanted to clarify the rights as to who owns geothermal energy. So the Act says the owner of the mineral title has the right to explore for, develop, recover, and manage the geothermal resources associated with those minerals and with any subsurface reservoirs under the ground. Now, the reason I call this the soft touch legislation is it means the Act applies. You'll note there is nothing there to say that the mineral owner owns and is deemed always to have owned the rights to geothermal recovery. It just says, declares that the owner, as of December 2021, the owner of the mineral title has the right to geothermal resources. So this type of act has a completely different effect. It doesn't go back retroactively and say that the mineral owner has always had the rights to geothermal energy. The act applies only from the date it was passed. And it doesn't even claim to apply to any property rights that existed before that date. So I think the correct view is to say this legislation is ineffective at suppressing the claims of the surface owner to geothermal energy, particularly when we think that in geothermal energy is frequently recovered by a closed loop system. Just think of the capital letter U. On one leg of the U, a well is drilled. Water is sent down through that well. The well is then continued through very hot rocks for some distance, and that's the bottom of the U, and the next side of the U is a well that is recovering water which is now heated. That's a classic geothermal energy recovery. Nothing is being taken out of the earth. All that's happened is someone puts water in the earth and takes the same water out. They don't touch or remove any subsurface rights. So it's pretty clear that in those cases, if we're talking about subsurface heat, at common law, that was owned by the owner of the surface of the land. Why? Because the subsurface heat was neither a mine nor a mineral, nor was it removed in any way by the surface owner. So that type of legislation it's called declaratory in nature, but it doesn't affect existing rights. And interestingly enough, in 1993, the legislation that empowered natural gas storage to occur underground in Alberta took exactly the same approach. So we have a real practical difference between the two styles of legislation. So geothermal energy is described as the natural heat from the earth that is below the basic groundwater protection. So we'd have to ask, well, natural heat is not a mine or a mineral, and that therefore, surely the surface owner, as I mentioned a few moments ago, held the rights to underground heat before the act was passed, and there's nothing in the act to say we've removed that right explicitly, which as Eran described is normally necessary in order to take property rights from somebody else. So there are two instances which are really controversial at the moment. And the third one, which has just emerged in the last 3 weeks, raises this very similar issue. The Alberta Energy Regulator is considering an application by Enhanced Energy for a carbon capture and underground storage project in the province. Obviously, we're all very excited by the prospects of carbon capture and storage, but there are 28 objections to that application filed with the regulator because there are mineral owners in the land in which the carbon is going to be stored, and they say the injection of CO2, carbon dioxide, will impair recovery of lithium under the ground, and the lithium is contained is dissolved in subsurface brine or salt water areas. So the question that has arisen now, is yet undecided because it's brand new, is who owns the right to exploit lithium? The Crown owns all water in the province, so the Crown would say, well, we own the water, we own the lithium, therefore we own lithium. The lithium owner will say, no, lithium is not water. lithium is stored in water, but it's not water, and therefore it belongs to us, the mines and minerals owner. So this is just the latest controversy on that question. And I don't want to stay underground for the entire presentation, so I did want to talk about some issues involving ownership rights and renewable energy. Everyone will recall we had a quote pause in renewable energy development from 2023 into most of 2024. And when the pause was lifted, the Alberta Utilities Commission, which is charged with deciding renewable energy applications, was given by the government policy guidance. And the policy guidance said there can be no renewable energy development on Class 1 and Class 2 agricultural lands unless a proponent can demonstrate the ability for both crops and or livestock to coexist with renewable energy generation. Now, many of you, I noticed, came from all parts of the province, including some very rural areas today. Everyone will recognize there that this policy creates an unusual restriction on the farmer's right to use the land as the farmer sees fit. The farmer might say, I want this solar project to go ahead on my lands, and the direction to the Alberta Utilities Commission is, do not approve that. Unless the proponent can demonstrate that the solar energy can be produced alongside the agriculture. So this is a very hot issue at the moment. It was used very recently to deny a solar farm application in the Westlock region of Alberta. And we've got a furious farmer who said, I chose this for my land, and now my rights to use my land as I see fit have been impaired by this direction from the government. And so we are facing, I think, a very hot issue in rural Alberta. Many people in this room will remember the Land Stewardship Act, where any form of interference with the rights of a farmer to farm their land was, well, to say the least, highly controversial. So I just wanted to end with that. What we tend to get are people trying to redesign their solar projects so that sheep farming is permissible with quite short sheep. So the idea being that under these circumstances, we're allowing livestock and solar energy generation to occur on the same plot of land. So that's where I will stop. My time is up, and I turn it over to the moderator for any questions.
Yes, please post your questions in the chat, or alternatively, you can use the hands up function, which is under the, just check, it is under the React icon, the heart-shaped icon at the bottom of your screen. Maybe I'll get things going. Thank you to both of you for your presentations. I think there was some really meaty stuff there to consider, and maybe I'll just start somewhat chronologically. Eran, your mention of the amendments to the Alberta Bill of Rights. Do I understand what you're saying properly is that you don't see those amendments substantially altering the law as pronounced by the Supreme Court in the Annapolis Group case? Were they more reiterated? And you're on, there you are.
Yeah. No, actually, the Supreme Court, its jurisprudence requires that two things be met for a constructive taking to occur. One is we would call the acquisition test. The state has to acquire something, whether it's a proprietary interest or now after Annapolis, an advantage. The second thing that needs to occur is the denial of all reasonable private uses of the land. But the Alberta Bill of Rights seems to waive one of those prongs. A taking of property under the Alberta Bill of Rights means an owner of property being deprived of all reasonable uses of that property. So no need for any acquisition by the state.
Right.
So in that sense, the test, the constructive the test for constructive taking in Alberta is more permissive. The threshold is easier to meet. But what I would point out is that the Alberta Bill of Rights, even though it is not a constitutional document per se, even though it is an ordinary statute, it is something that's significant in terms of what it symbolizes, the approach that the government wants to take, and this can affect the court's interpretation of property and rights in Alberta moving forward.
Okay, thank you. I saw a hand go up there, but it disappeared quickly. Here. So Cindy is asking, any idea when regulation will be determined regarding brine and lithium rights? I guess that's for you, David.
Yes, I haven't a clue. I think it's the application was something like December the 12th, and the 26 statements of concern have been filed since then. So this is a brand new issue. And it's very interesting because both uses of this type of property, both the lithium and the use for carbon capture and storage, are major public policy concerns. Obviously, lithium is a key strategic substance today, and at the same time, the province really wants to have workable underground carbon capture and storage regimes. So I'm not even sure that it's hit anybody's radar screen yet, other than that of the Alberta Energy Regulator, who's sitting there, no doubt, scratching its collective head, saying, we've got a tough one to deal with here. I think the argument is very clearly that the lithium is owned by the Mines and Minerals owner because although it's contained in water, it's not water. It's lithium. So that's how I see it at the moment. And I don't even know which way a government would want to go in deciding that.
But it is an issue that's working its way towards resolution pretty quickly, or at least maybe not resolution, but some development in the near future.
Right, because the regulator has to decide whether to issue a permit to carbon capture and storage company or not, which will effectively, and that decision may well trigger a lawsuit by the losing party.
We have another question. I think this one's for you too, David, from Cindy McKenzie. I wonder if there are similar restrictions on non-renewable resources, such as sand and gravel extraction, if they conflict with farming or cropland or agricultural activities.
No, there isn't. And one of the interesting things about the renewable energy situation, saying that it will not be improved on class 1 or class 2 lands unless it can be carried on with agriculture, is in every other respect, we seem to give a free hand to people who want to develop farmland in any way, which is why it's being gobbled up around our major cities today. There's no protection for it whatsoever, or for other energy projects which cause permanent loss of agricultural land. Well, and a simple example which doesn't exist very much anymore, something like strip mining used to be permitted on farmland, even though it essentially destroyed the land for future prospects. So the odd thing is the only thing that's singled out is renewable energy. But other activities, sand and gravel removal, peat removal, not at all.
Thank you, David. Next question is from Gordon Davidge. Can we have a discussion regarding the end-of-life obligations renewable energy? That's a big topic, but maybe we can touch on it quickly.
It is covered in the new rules relating to renewable energy permits, that there has to be a satisfactory scheme for the removal of the superstructure, if you like, of renewable energy at the end of the project. It's a far more stringent standard than is used in the oil and gas industry at the moment, where, of course, it's extremely easy to evade the restoration requirements, as we know through the Orphan Well program, by simply becoming insolvent. Which is what's happening with our ever-expanding number of orphan wells at the moment.
So again, we seem to be singling out renewable energy for a higher standard of performance.
Yes, and it's undeniable in both instances. Yes.
Yeah. Okay. Question from Wendy Culkin. Can you explain the parameters of adverse possession? That was not a topic that came up, but I know it's always popular to consider.
Yes, I can take this one. Adverse possession is a very old rule that limits the time during which an owner can bring a claim in the courts to recover possession of his or her land, which was interfered with by a squatter. In Alberta, the rule was that after 10 years, the trespasser has immunity from liability. However, after fairly extensive consultation, the legislature has abolished adverse possession in Alberta, which means that the owner's right to recover possession is no longer time limited.
Thanks for clarifying that, Eran. I had another question for arising out of David's presentation. This one was about the geothermal resources. You pointed to the policy or the regulation, I believe it was, saying that the owner of the mineral rights has a set of rights with respect to the exploitation of the geothermal resources.
Yeah.
But my understanding is there's often multiple owners of mineral rights underneath a particular piece of land. It may be different strata, or the gemstones, coal owner, petroleum owners may all be different. So how does that mean that each one gets to exploit the resources within its particular bunch of rocks?
Well,
Or
that's a very good question. It means the proponent of the geothermal project has to deal with, I would say, the owner of every mineral, and it can be easily be two or three minerals. Petroleum, natural gas, and coal could theoretically all be in separate hands, and has to deal with the surface of the land owner, because as I maintain, the Act doesn't suppress any rights the surface owner might have had to geothermal energy. And if you apply this, Saskatchewan in the Estevan region has a DEEP, a deep energy geothermal project, which covers 36 sections of land beneath the surface. And if you could imagine a land agent being told, now I want you to get the rights to every mineral owner and every surface owner of 36 sections of land, which is what the Alberta requirement would suggest, they have an impossible task on their hands. So yes, there are more ownership interests recognized, I think, in respect of geothermal energy that create very high transaction costs to develop geothermal energy, except on land where the province owns the surface and the mines and minerals.
thank you for clarifying that. We have a question from Brian O'Born. Any thoughts from Iran in terms of how Israel deals with surface and subsurface property rights that we could learn from? I suspect there's some
Not
background
really.
knowledge behind this question.
Not really. My expertise is in Canadian expropriation law, and I think you'd have to ask an Israeli academic
Uh,
specializing in those areas.
Brian, I don't know if you want to, if there was anything behind your question that you wanted to explain.
Sure. I did spend some time there myself, and I know they have some interesting different property rights regimes, and I don't fully understand them. And I was thinking maybe around, given your background, maybe you might have some more details. But as I understand it, farmers lease their land for 99 years. And so the
That
whole issue of property rights is quite different. And I don't know how they deal with subsurface resources at all.
right. The long-term leases are quite common throughout the world. You can find them in former British colonies. I believe that all land in Canberra, Australia, is leased for 99 years. It might also be the situation in Hong Kong. I'm less sure about that. But Yeah, I would have to look into it and explore further the interplay between the
Thank you
long-term
very
lease
much.
system. Yeah.
As a Canadian, trained in private property, it was quite foreign to me. So I was I'm interested in it. Anyway, thank you very much.
No
Thanks
problem.
for clarifying that, Brian. And it actually gives rise to a question that I've been asking ever since I took property law back in the Stone Age. Um, 99-year leases. This is we're going somewhat tangential, but in the absence of other questions, what's the magic of the 99 years? I always assumed that there was something about 100 years that tripped some legal doctrine or problem, but I've never been able to find what that was. So, can either of you set me straight on that?
I can't. David?
I've always assumed that at the time it was the maximum conceivable lifetime. That's that's the only thought I had that made it the why that was picked and not 101. Each of them had the right ring, 101 Dalmatians, 101 years, but that's all I can think of.
Okay, thanks. I I I gather the real question is nobody really knows. It's the real answer. Yeah.
Might be the
But just
number
tradition.
of bottles of beer on the wall.
Yeah. Any other questions for our speakers? This is a pretty good opportunity, as you can see, to cover a lot of ground
Dave, I
in
see a
this
question in the
important
chat
area.
from Angela.
Oh, I, well,
Yeah, it's you were asking about resources where a municipality expropriated private land without landowner consent or compensation. Well, the Municipal Government Act does give municipalities expropriation powers, but always with compensation. So I'm not familiar with expropriation by municipality without compensation. Was there anything?
I'll just speak out on this one. This is an estate matter, and it was done sometime in the 1980s for a roadway, and they just assumed a portion of a municipality land, and without any sort of consent or compensation, they just built the roadway over a corner of this property. So I've got some information about it, but the municipality is challenging me on their records. They don't have the records. So I've been looking for ways to battle this. And I understand that the Expropriation Act goes back to about 1970. Is that correct in your recollection?
There have been several iterations of the legislation, but municipalities in Alberta could always expropriate, but with compensation.
Yeah,
It's
there
hard
was
to
no
comment.
compensation. Yeah,
It's hard to
so
comment on a particular case without knowing all of the.
details. Yeah, no, I
Yes,
appreciate that. Okay, thank you very much for your
you're very welcome.
attempt.
see, we've got another question from Cindy McKenzie. Where could I find more information about the landowner's rights for protection of their water wells in the case of adjacent aggregate extraction within the water table?
I do groundwater. It's not an issue I'm familiar with. The what the groundwater regulations that deal with are more competing wells than the fact that I don't think it's regulation of the landowner's rights. I think it's an example at most of the possibility of the common law of nuisance and those circumstances where the use of one person's land impairs the use of a neighbor's land.
Hmm.
That's the only way I can think. It's not dealt with in the regulations, to my knowledge.
It's not clear to me whether Cindy's question is about contamination of the water or a disruption of the water table somehow to reroute the water. But um, I see Brent has a hand up. Brent, do you want to come on and ask your question?
Presentation. Hello, can you hear me there?
Yes.
Okay, yeah, I was just saying thanks for the presentation there. I found it quite informative. I guess I would ask the question to the group here. Um, been Albertan, born and raised. I was just wondering, with the expertise in the room, where would you state, and maybe it's not a question that can be answered, but you know, I feel like Alberta has always kind of been, in my experience, on the cutting edge, so to speak, in terms of we have licensed land agents in the province acquiring certain things. Where would you say we are as compared across the nation in terms of our property rights sort of framework and stuff? When you think about Alberta and you think about perhaps a conservative sort of framework and that sort of thing, the things that come out in the news in the last 4 years have been maybe a little bit more geared towards property rights. So I was just wondering, as compared to, say, Nova Scotia, Ontario, British Columbia, for example, are we all sort of on the same playing field in terms of landowner rights, I guess? I know that's kind of a way open-ended question and a long sort of thing, but I was just curious, more or less. Anyways, thanks. Thank you very much.
I'd like to take a dig at that. The subsurface legislation that I talked about, which declares who owns sand, gravel, clay, marl, coal bed methane, pore space for the protection of carbon capture, is generally highly intrusive legislation. I mean, basically takes rights away by statute with no compensation for the person who claims that this conflicts with an existing right. But what happened is that in 1993, when the Natural Gas Storage Act was passed, the pendulum swung the other way. The legislative class of 93, as they're known, were very pro-property rights. And so was the UCP government recently elected, because in the 2019 convention, they made very strong resolutions relating to the protection of property rights. So in Alberta, the pendulum has swung. One of the reasons that Alberta opposed the enshrining of property rights in the Canadian Constitution in 1982 was they realized that many of their pieces of legislation dealing with energy production actually would have constituted an invasion of property rights and could be litigated under the Constitution, which is why Alberta was opposed to putting property rights into the Constitution when other provinces were interested in the possibility.
Yes, very, very, very good answer. Thank you.
It's very, very interesting. Thank you, David. I'll take one final question in the chat, and then I'll turn it over to Aisha to wrap us up for today. The final question is from Lavina. In renewable energy projects, is there any legislation that protects adjacent landowners from adverse effects without any compensation? Or I guess with or without any compensation, maybe another way to put it.
There's no explicit provision for compensation at all on adjacent lands. The interests of adjacent landowners are often raised in renewable energy development applications, and I would say that they have rarely succeeded. I'm not sure. I haven't read all the decisions. I can't say they've never succeeded, but the ones I've looked at, they've not succeeded, and I'm not sure. It certainly doesn't protect the adjacent landowners any better than traditional energy projects. The commonest issues involve wind turbines and noise. And there are a few standards now dealing with noise and maximum noise in the air shed of the development, but that's about all.
And I presume that would be mainly dealt with by the common law of nuisance. Is that right?
Yeah, and it's very, very hard to establish. But now, I mean, certainly there are limits now on wind farms, on the density of wind farms, so that some of the new approvals say, for example, that only a certain number of turbines can operate during the night because of the noise factor. But it's dealt with in that way, but they are now looking particularly at the noise and also the viewscapes and wind turbines.
Yes. All right. Well, thank you. Thank you to both of you for the presentations, and to all of you, the that raised very good questions and gave rise to a very, very stimulating discussion. Aisha, do you want to wrap us up, please?
Absolutely. I'll just say another thank you again to Eran and David for your time and expertise. And thank you for moderating, Dave. The recording of this session will be made available next week on our website. That's uab.ca/ALI. We will be holding more free lunchtime webinar sessions, so you can keep an eye out for that. And thank you to everyone who took the time to attend today. Thank you for all your questions and for your discussion. And that's everything. Take care, everyone.
Thanks so much.
Thank you.